We're getting ready to start. Good morning. Welcome, everybody. We're really pleased to have you here at Duke Law School. We really welcome the animal law scholars, community who've joined us here today, and also Duke Law students. We're really pleased to have you here for Duke University's Animal Law Conference. I am Kenny Ching, and if you have any questions throughout the day, please feel free to flag me and let me know. I would like to quickly take you through a few things in the itinerary. If everybody's received a notebook, there are a few quick things in terms of speaker changes. This first panel is actually has been reversed from the cover page, but the interior itinerary is correct. The second half of the day, the first half of the day will all take place in here, the first two panels. The second round of speakers after lunch will be in a room next door, 3041, and that's not listed totally correctly here on your itinerary, but the second half of the day will all be next door in a slightly larger room. And in terms of lunch, for those people who are pre-registered, there will be a vegan lunch in the Birdman Lounge, and there'll be students to direct you in that way. And for other people, your information here has a list of dining options on campus and a map, as you can see here in the front pocket. I would like to now have Dean Catherine Bartlett up to say a few introductory remarks. Thank you for being here.
Thank you, Kenny. I want to welcome you all here to Duke Law School for this, what seems to be extremely well-organized and well-conceived conference on animal law. I want to start by thanking Mr. Bob Barker, whose gift to Duke has enabled this conference and a number of other of our activities in the animal law area. I don't know whether Bob Barker will watch the tape of this conference, but I'm hoping that he will so that he can see that his money is being put to very good use. And in the event that he is, I wonder if we might have an audience recognition of our appreciation for his support, not just of this law school and its efforts in animal law, but more his broader efforts throughout the nation. So a round of applause. Now, Bob Barker was interested in Duke, of course, because Duke already had kind of a beachhead in the animal law area through Professor Bill Reppy, who was on our first panel. Many of you have worked with him, have been kind of in the vanguard along with him in terms of legislation in North Carolina and litigation and activities elsewhere. But I want to recognize Bill's contribution to this area of the law. He is an expert in other things as well. This is kind of a hobby that has become, I think, a bigger and bigger part of his area of both scholarly and very personal interests. So I want to thank Bill. He teaches an animal law course, and now as a result of the Barker donation, we also have an animal law clinic, which is run by one of our graduates, Jeff Welty, whom I also want to recognize. I think together we have a lot of leadership in this area of law, and we're just really happy to get some more brain power and passion as we have in this room together to think through some of the issues that you'll be discussing today. I want to thank also the student editors and leaders on the L&CP journal, the Law and Contemporary Problems journal, especially Kenny Ching, who I know has worked, I just learned from his roommate, really day and night to make all of this come together, and I'm really pleased for that kind of student leadership. And for all these people, let me ask for another round of applause. Linda Greenhouse from the New York Times was here a few weeks ago. We did an interview of her called My Life in the Law. It's a series that we have of folks who have made an impact in the law. And part of her story was about how when she graduated from Radcliffe College, she couldn't get a job in the traditional areas. And we were, she and other folks who were our age, she and I are exactly the same age. And I think some of you in this room are maybe as old as that too. we're talking about how in the late 60s, many opportunities that weren't open to us, we sort of just took it. We just didn't think so much about how we couldn't go to Yale, or we couldn't do this or that, the other thing. We couldn't have a certain kind of job, because that's just the way the world was. And at lunch later, we were talking about what is the issue which, and we were embarrassed by this. She and I were both embarrassed that we didn't have a bigger consciousness back in 1968. It didn't develop until 1970, 1971. And at lunch, someone raised the question, what's the issue now that 20 years later, 10 years later, we're going to be embarrassed that we didn't have a sensibility or a consciousness about, and that we're kind of missing the boat on right now, but we'll later on see that we were absolute idiots or fools or really without conscience about things about which we needed a conscience. And the best answer that anyone gave is how we think about animals. And so that kind of has been growing in my own mind, and for those of you who have a deep interest in this area, who have developed some sense of the importance of the issue, this may not resonate because you're way ahead of the rest, but I think that it's important. If it'll be not only interesting, but obviously a matter of great social importance, how this develops in terms of the public view and general consciousness about what's right and wrong. So I see this conference as an important conference for developing the legal framework around which certain things that don't seem obvious now to people may someday seem like things that should have been taken for granted. So thank you all for coming. I hope you will take the time. It's a gorgeous day. I don't know what time how packed your schedule is, but it's a beautiful time to walk around Duke campus. There's not a well-tread path, but it's not very far to get to the Duke Gardens, which I was at the other day. They're absolutely beautiful. There's still a lot of tulips and other bulbs up, and also roam around the law school and see some of the changes that we've made here. Again, thank you for coming, and thank you for all of our out-of-town guests who have come to bring their brain power and their ideas to animal law issues. Thank you.
Thank you, Dean Bartlett. We're fortunate to have the support of the administration here at Duke, led by the dean, for a study of animal law. And as she mentioned, we're also fortunate to have a wonderful journal here, Law and Contemporary Problems, which has taken the lead on this issue and has organized a fantastic conference and is going to be publishing a symposium of writings by folks who are participants here today. So we are fortunate here at Duke. As Dean Bartlett said, my name's Jeff Welty. I'm an adjunct professor here at Duke, and I direct the Animal Law Clinic. I am also the moderator for our first panel, the title of which is Promotion of Animal Welfare, Legislation, Mediation, and More. And the common thread for this panel, which has some diversity within it, is that each speaker is going to be addressing a particular tool for improving the lot of animals. The focus isn't on a particular type of animal, like dogs or pigs, or a particular setting, like farms or pets or wild animals, but rather it's on a spectrum of general approaches that might be used in different contexts to improve the lot of animals. And we've got three speakers, each of which is going to speak about a different tool. And the different tools, some may get more favorable reviews from the speakers than others. I'm going to introduce each of the speakers and then let each of them talk for about 20 minutes. At the end of that, we'll hopefully have 10 or 15 minutes for questions and comments from the audience to get you all involved and get your thoughts. And we should be done about 11:15 to give everybody a short break before the next panel starts. Our first speaker is Bill Reppy. He's a graduate of Stanford University and Stanford Law School. He clerked for Justice William O. Douglas on the United States Supreme Court. He has been a law professor here for 35 years, was the first professor in North Carolina teaching in the field of animal law, and has published widely in that field. He is on North Carolina's General Statutes Commission and has led the charge to reform our state statutes in a number of areas that relate to animals, and he will, as you might expect, be addressing legislation, and particularly North Carolina's animal cruelty laws and the exemptions to that. When Bill is done, we'll hear from Taimie Bryant, who's seated now next to me. She received her JD from Harvard University, has a PhD in anthropology from UCLA, where she has been on the law faculty since 1988. Since 1995, she's focused on animal law and has worked to revise California's sheltering legislation and is increasingly interested in the subject of legal theory, and that is the topic that she'll be addressing today, whether we can improve animal welfare by re-envisioning the way that we think about animals in the law. And our last speaker, but not least, is going to be Kathy Hessler, seated furthest from me. She received her JD from William & Mary, an LLM from Georgetown, and since 2000 has been a professor at Case Western Reserve University. She's interested in animal law and what we call alternative dispute resolution, or ADR, and she will be addressing whether animals' interests can be effectively protected through mediation as opposed to more traditional means like litigation. So that's who you'll hear from, and you won't hear much more from me. I will turn it over now to Bill Reppy.
Thank you, Jeff. The title of my short address here focuses on the word disdain. Lawmaker disdain for animals. I think it's there. I think I'll show you that North Carolina is a good example. And because the present situation by lawmakers, by which I intend to include both legislators and judges, because of this lack of interest in animals, we need reform. And that's why we have this session, the first one, talking about new approaches to law reform. Things started going very badly for animals in the common law courts, the judge-made law, well over 200 years ago. The common law came up with the remarkable and incredible notion that an animal, and it's especially incredible when applied to a companion animal like a cat, a dog, or a parrot, is just a piece of property in the same way as a chair, a book, or a plow. And if you attend all of the sessions of our conference today, you will see how this rule of common law, which we all know is contrary to common sense, has affected animal law in this country. It could have been quite different. The initial ruling could have been that animals are a very different type of property entitled to quite different rules when compared to a chair, a book, or a plow. Well, since the common law courts were not going to give animals a good break, and nothing's really changed very much in common law rulemaking concerning animals since this initial and dreadful ruling, it became necessary to turn to the courts. And the initial step was animal cruelty laws. They do treat animals as different type of property, but in a limited way. There's no book cruelty law or chair cruelty law or plow cruelty law. So it is a fact that the legislators, to that extent, treated animals, still considered property, a little bit differently. The laws were originally rather narrow. Sometimes they would name the protected animals. Sometimes they would just, certain acts like beating were listed. And from the start, there were exemptions. Originally, it was just the state governments, North Carolina, New York. New York was the leader, one of them. North Carolina got aboard in 1881 with its first animal cruelty statute. But then the federal government started a little bit passing laws, which will be explored by various of the speakers in today's conference. But this also was sort of a small, timid step by the federal government. The perfect example of how we can say that even the Congress is showing its disdain for animal interests is the scope of the Federal Animal Welfare Act. You may have heard of it. It's possible that a huge scope of animals could have found some protection under this federal law, but they don't. Farm animals are exempt. That's an enormous number of animals. In laboratories, the most commonly used animals on experiments by vivisectors are mice and rats. They are exempt, as are birds. So when I start talking about the rather extraordinary exemptions in the North Carolina anti-cruelty law, this is not unique. The federal law is rife with exemptions. The Georgia anti-cruelty statute is just about as bad as our own. My research has discovered that only 4 states have no exemptions at all, and one of those 4 is Massachusetts, which exempts worms placed on hooks by fishermen. I don't really count that one as an exemption because I don't think any prosecutor ever would have brought an action against a fisherman who put a worm on a hook. No exemption is at all necessary from any logical standpoint to an animal cruelty law. And here's the reason why. The laws are written to say that only unjustified acts of cruelty are criminal. They all say that. If they don't say it directly, the court system in the state that passed the anti-cruelty statute will have so held. Now think of a vivisector experimenting on animals. The prosecutor's not going to bring a suit even though there's no exemption if the laboratory can show that something is going to be gained for human beings based on the experiment. That means that it would be justified. A veterinarian is docking the tail of a dog, wonders if he's going to be prosecuted, he or she, without an exemption in the anti-cruelty statute. Well, you know, there's such a tradition, and with the kennel associations demanding that dogs sometimes be docked before they can be shown. This is going to pass muster under the rule that only unjustified cruelty can be prosecuted. So there really is no need for an exemption. North Carolina, for the first 110 years of the existence of our animal cruelty statute, had only one exemption, and it was very narrow. And it was for hunters, and it was a provision added in 1883 that there would be no criminal prosecution of a hunter for shooting an animal for food. That is very narrow. And it was probably justified anyway. It's really not an exemption, because if food was the purpose of the shooting, there never could have been a prosecution anyway. So it wasn't until 1998 that our state animal cruelty law got very much exempted. The criminal cruelty statute is section 14360. And the introduction to the list of exemptions is in the language there on the screen. This section shall not apply to the following activities. This section includes a misdemeanor cruelty provision for intentional wrong, but that's not malicious or with bad motive. And it also includes a felony provision that was added the same year that an expansion of exemptions struck the North Carolina statute. The story is that a bill was presented in the North Carolina legislature to add a felony provision. I'll have the wording of it up there shortly. Originally it didn't cover all animals. It only covered cruelty to useful animals. And animal rights organizations didn't like that, and they got a senator to put in an amendment that broadened it to all animals. But there was a trade-off here. He decided to get the support he needed for this amendment, he would create an exemption. And he created 4 or 5 exemptions. And this blossomed up in over 2 years to a total of 9 exemptions. And I will be showing you in the next 5 minutes that these exemptions really are absolute and are shocking. Remember that felony cruelty includes malicious torture with a bad motive. And remember, it's important that the original notion of why we have all these exemptions in North Carolina was to get the votes to insert into our statute a felony provision with stricter jail time and fines. So there is very definitely a connection in the history of the North Carolina statute between the existence of a felony provision and the existence of the exemptions. Most of these exemptions refer to, well, they all refer to activities. None of them exempt an actor in a certain capacity. For example, a biomedical researcher is exempt for activities and not because he or she is a researcher. So this individual who batters his cat at his home is not exempt under this statute, but for extreme cruelty to animals in the laboratory, there is an exemption. Notice the word lawful qualifying the hunter's exemption and the for purposes of biomedical research. The meaning of this is unclear, but I think I know what it is, and I don't think it helps narrow the exemption very much. With respect to hunters, the original context was that the hunter should have a license. The hunter should not be using a weapon that was banned. The hunter should be in season. That's what lawful meant. And this word lawful dates to 1883, and we see the context of its meaning in the hunter's exemption. Lawful modifies all of these on the list of exemptions. Production of livestock, we'll be talking about that one. It's lawful production of livestock that is exempted. Let me just go back here to, we're going to talk about for purposes of. If you see lawful activities for purposes of, that's something I'll be talking about also in a moment, to see whether that narrows our exemptions so that they're not draconian and dreadful. The conclusion will be that it doesn't narrow them. And this is the complete list of our 9 exemptions. There is some limit, probably, on the hunter's exemption because it refers to a taking of animals by a hunter or a trapper, and it includes also some fisher people. And there is a statute, not in the criminal code, but dealing with regulation of wildlife that defines taking. And the key word here, I think, is immediately after the attempt to kill. So I'm hoping that we can narrow the hunter's exemption somewhat. If a hunter wounds an animal and takes it home and beats it up all the way in the bag on the way home, this hunter is not operating immediately after the attempt to kill the animal that it wounded. So we can take this definition and narrow the hunter's exemption somewhat. A trapper who leaves an animal in a trap for hours and hours and hours and hours while that animal suffers may find that the word immediately here is depriving that hunter and trapper of the exemption. Well, let's talk about lawful. The very first felony prosecution under the North Carolina statute was in Camden County down east in the heart of hog farming, and PETA had infiltrated a big hog farm operation, sent in a mole with a camera that took videotape of some horrible beating, almost torture, of some of the animals there. And PETA sent the video to the prosecuting attorney, the district attorney, and asked for a felony prosecution. And this on the board is found in PETA's letter. It's the attempt by PETA to explain why the exemption for lawful production of livestock didn't apply to the activity in the film, that it was basically so horrible that it couldn't be lawful. Well, folks, we know from the legislative history of the North Carolina exemption law that it was addressed to felonies. It was addressed to actions that are maliciously done with bad motive. And so PETA was wrong in trying to say this just couldn't be lawful. What they're saying is you don't get the exemption at all because it's so bad. What you're doing is so bad, and yet it's perfectly clear from the statute that the very worst possible activity that falls under this definition is entitled to the exemption. So what is a lawful production of hogs? Well, I suppose that you have to be within the zoning. If you're in a residential zone and you're having a giant hog farm, you're probably not lawful. We have statutes regulating hog lagoons. I suppose if you're violating those statutes, you're not a lawful hog producer. I suppose if you're hiring illegal aliens, maybe you're not a lawful hog producer. But certainly the fact that incredible cruelty is going on just doesn't have anything to do with the meaning of the word lawful there. It just can't. There's a California case. What happened in that case? What happened? The DA did prosecute. The defense attorney dumbly pleaded his clients to misdemeanor cruelty, and justice was done, but it shouldn't have been. If the attorney had had any sense, would have invoked the exemption and the argument I just made. There's only one case I have found dealing with an exemption and somewhat following the PETA argument. It came out of California. There was an exemption to the felony cruelty statute in California for killing vermin, including mice. And the defendants made what is called a crush video, where these people with high heels were jumping up and down on mice and killing them. They were prosecuted. And the California court applied the maxim that we shouldn't construe the law to produce an absurd result. But hey, California has the same legislative history we do. It was very, very clear that they did intend the absurd result. Well, I don't think that was a correct decision. I don't think we'll ever get a North Carolina court to do that and to nullify the exemptions on that theory. What should we do? Well, I personally tried to do something about this. As Jeff has said, I'm on the General Statutes Commission of North Carolina. Each law school has a representative there, and I'm sort of the pro-animal mole in that organization, if you want to talk about moles. I proposed a bill that the commission unanimously adopted, that we add to the exemptions that a provision that would apply only to commonly accepted practices. That would mean debeaking of hens is okay. Docking tails of dogs is okay. Unfortunately, gestation crates for piglets and sows would be okay. But certainly the activity in the PETA video is not commonly accepted practice of hog farmers. And so my bill to narrow the exemptions would have had some benefit. Not as much, we should have got rid of them entirely. There's no need for them. Well, guess what happened to that bill? It got into a Senate committee and was thrown out immediately. The lobbyists for the vivisectors, the researchers, medical researchers, and for the veterinarians, remember there was a veterinarian exemption, descended upon the legislature here in Raleigh, and so much for that bill. It died. Well, now, what are we going to do now? I'm writing an article for this symposium that will be published in our journal, faculty-edited journal here, Long-Term Problems, is laying out what you do. Go into the courts and argue that these exemptions are unconstitutional. And here's the theory, that what's common about the 9 actors who get this absolute exemption? Hunters, vivisectors, veterinarians, livestock, what's common about them? They all interact with animals. But there's a whole other group of people that likewise interact with animals. Horse trainers, dog groomers, operators of pet daycare centers, operators of boarding kennels. You can go on the list. They don't get the exemption. Well, can this be explained? The Equal Protection Clause of the Federal Constitution of the 14th Amendment is directed at state statutes and other state action and says there must be a rational basis. There has been one case in history in this country where an exemption to an anti-cruelty statute was attacked in the court system for denying equal protection. It's a 1953 Florida case. The statute said that the anti-cruelty law didn't apply to poultry on board ship. The idea was that there would be cockfights on these pleasure cruisers that were sailing around Biscayne, or that you'd go there and have your drinks on board and watch a cockfight. And the Florida Supreme Court unanimously and very quickly shot it down as totally irrational. That if cocks needed protection from cruelty laws, they needed it on sea as well as on land. So there is some precedent. What's going to be the success when this attack is made on the North Carolina exemptions? Are we going to win? I don't know. I've litigated 2 cases in the Carolina Courts of Appeals on behalf of animals, and each time I lost, I thought on the narrowest technical grounds they were picky, picky, picky. I sensed an attitude in the judges in the appellate court of sort of dislike of us do-gooders, who are messing around with things, like attacking laws as unconstitutional. We have a good argument. I don't know. In any event, I would just close by reminding you why I spent all this time on the North Carolina exemption. This is just simply unbelievable that the state legislature would allow malicious cruelty, felony cruelty, by a broad group of people that interact all the time with animals. We need reform, and Professor Bryant has got some theories, and we'll hear from her.
Thank you very much for this opportunity to join you here at Duke Law School to talk about a subject that I care very much about. Much of the discourse about helping animals makes use of an argument that we've seen in many other contexts, and that particular argument about justice is that like entities should be treated alike. If animals are like people, then like people, they should be protected from harm. Not just any old similarity will do, however. Animals have to be similar to humans in relation to defining characteristics of humans. So we've explored, as animal advocates, defining characteristics such as cognition, linguistic ability, emotional capacity, the capacity to suffer. Intuitively, this is an appealing argument. It's intuitive because perhaps the idea of equality and equal treatment, to be equally protected from harm, is a very strong current of belief in our society. That notion of justice is very embedded in our legal system. However, I would argue that reliance on this similarity argument also contains some highly troubling aspects. First, I would note that in the similarity argument, that animals are like humans and therefore should be protected from harms, there is a use of humans as the measure of what is valuable. And I come to this subject with concerns about using an external measure of worth based on my sensibilities as a feminist and my sensibilities as an individual woman who did not particularly like the argument that women needed to be seen as like men to be able to have access to the workplace and protections that men already enjoyed. Human beings becoming the measure of all worth, that is, entitlements to protection and rights, does violence to both sides of the equation. Humans are seen as static, so it does violence to the concept of diversity among humans that we're gradually becoming aware of in this society. And it does violence to the side of animals, that is, they will be measured as to their worthiness to be protected from harm in relation to the extent to which they mimic the qualities of the superior protected group. You're nothing if you don't approximate a human. Now, the argument has been that if we can first show that great apes, for example, are like humans, we extend those protections to great apes, then we will have broken through the sound barrier, so to speak. People will hear us when we talk about other animals that don't have exactly the same configuration of qualities as great apes in relation to humans. I don't think that's likely to happen because the measure of worth is always going to be humans, not great apes as humans or the rendition. So horseshoe crabs will have to be compared to humans, just as great apes were compared to humans. And so I don't really think that we're going to see any breakthroughs by first choosing an animal most similar to humans and then hoping that there will be trickle-down effects. I think that this also creates, the similarity argument, also creates a hierarchy of worthiness between and among animals. And that hierarchy of worthiness, then just getting animals into the protected circle won't help us ultimately downstream if they happen to be in that protected circle as to deciding their relative rights. So I see it as creating downstream problems for us as well as very real upstream kinds of problems for us. I think that there's a lot of intuitive appeal to the similarity argument. When legal entitlements are at stake, similarity will be pushed to the limits so that it's one thing to say that great apes are like us, that chimpanzees have many of our characteristics, but when the entitlement to use them in experiments is at stake, when the entitlement to use them as performers in TV shows is at stake, those people who hold those entitlements will push the similarity argument to its limits and define animals, chimpanzees, as different enough from humans that we should not provide the same kinds of protections. It's odd to me in this society where humans are defined by reference to oppositional category animal, that we would think that we can break down that oppositional defining characteristic of animals in order to give them access to protection. When an animal comes close to being seen as like a human, we quickly redefine ourselves as humans so that we can reassert the dissimilarity. So the harder that advocates work to show the similarity, the harder opponents will work to redefine humans so that humans will be seen as dissimilar and as more worthy of the protections that humans give each other. I also dislike the similarity argument because I believe that it contains a tremendous assimilationist bias. You gain entry to the community by reference to your similarities to humans, but what are you going to do once you get in there? You can't reform the system by reference to your differences. And the example I'd like to give is a very short sort of review of the feminist experience with this formal equality approach. In the 60s and 70s, women made use of the claim that women are like men for all relevant purposes when it comes to the workplace purposes. And so they should have access to work. They should be able to work just like men do. So they made the similarity argument in order to gain access. Well, they gained a certain amount of access. And they get in there, and lo and behold, women are not like men. They get pregnant. They have babies. That's like a difference. And it's a difference that then begins to affect the work setting. So they get in to the work setting on an argument, we're just like those guys. And then when it turns out that they're not just like those guys, they're in a pickle because now they have to say we're different and there should be an accommodation. So the first working out of this was the Pregnancy Discrimination Act of 1978, enacted in 1978, where women made use of the same similarity argument. They said, look, if an employer provides disability coverage for temporary disabilities that men have, then employers ought to provide temporary disability coverage for women who are temporarily disabled. And that kind of stuck in the throat. Pregnancy, disability, like this is a normal life cycle event, but we got to call it a disability because we got to put ourselves in the box that employers are already recognizing by reference to men. And so the Pregnancy Discrimination Act provided that if an employer provided any temporary disability provisions for male employees, they would have to do so for women. Well, in the meantime, feminists were talking about this discourse and the stick-in-the-throat phenomenon of disability and labeling women's contributions to society as somehow related to their disabilities in pregnancy. And so that debate came forward in the next iteration, which was the Family and Medical Leave Act, enacted in 1993. And the underlying thesis of that, it's very problematic in its operation, but the underlying thesis is for the Family and Medical Leave Act is that employers should anticipate the need for all employees to take periods of time off to assist family members or for their own medical leave purposes. And actually, it's being used quite a bit for non-pregnancy maternity leave kinds of situations. I don't see that as problematic. I see that actually as a window into a shift in presumptions. Previously, the competitive advantage for employers would lie in excluding those people they thought would be temporarily or permanently disruptive to their organizations. And with the Family and Medical Leave Act, now competitive advantage would lie in an organizational that had sufficient flexibility to withstand temporary absences by individual employees. So employers' competitive advantage now was not in an exclusion. Employers' competitive advantage now was in creating flexible organizational strategies and structures that would accommodate anybody who would need to take some kind of a break in their regular service. Now, how does this relate to animals? If we're hung up on the similarity argument, the formal equality argument that women first used and that women, feminists, have started moving away from, if we're hung up on proving that animals are similar, we don't turn our focus on re-envisioning the world as though animals matter, carving out spaces for them so that people and societal institutions have to take account of the diversity that's present in animal populations. The question should not be, how closely do animals approximate humans? The question should be, what would or should an animal-friendly world look like? And so I started looking around to see if there's any precursor to this in the animal advocacy area. One venue that was, or avenue that was suggested to me was the Endangered Species Act, which doesn't require for protection of the animal or animal species that an animal be like humans. Invertebrates are protected, plants are protected, animals of all kinds, many we've never heard of, are protected. But it's very shallow protection in the sense that it only keeps the species alive. Individual endangered species, like a chimpanzee, could be used in experimentation, could be used for entertainment purposes. So it is shallow in the sense that it is narrow in its coverage of all the harms that could happen to animals. But it's broad in the sense of what it includes, which is all kinds of animals that don't even look like or approximate humans. Another example is wildlife corridors, and these are overpasses or underpasses constructed over or under roadways that cut through habitats. Overpasses designed to enable wildlife to continue to interact with each other, literally get to the other side of the road. And it protects mice, it protects what people have called vermin, it protects animals we say we care about, animals we have never said we care one way or the other about. It's very broad, again, in its coverage of who it is, and it envisions a world in which naturally animals ought to be able to get to the other side of the road. It's very hard. Those are wildlife examples. It's very hard to put that into a factory farm animal context. What? We're going to treat factory farms like employment settings, and what would a chicken want on the way to be turned into flesh food? I mean, we are so far down the road in turning these particular animals into machines for us that to use a wildlife kind of situation by way of analogy is very, very difficult. There's a huge divide that opens up. And so I think, what would an animal-friendly world look like? And how do we apply that in the factory farm context? I think it's very interesting that many of the presentations today will look at the question of switching consumer preferences so that we ultimately do create the animal-friendly world of not using animals for human consumption purposes. So here, I have to leap all the way to what would I do if I wanted to create the means by which the animal-friendly world is here now? I'd open a vegan restaurant. Of course, it couldn't be just any vegan restaurant. It has to be a vegan restaurant where the food actually tastes good, because otherwise you will set the cause back, right? If you just have the alternative, the animal-friendly alternative, not appear to be viable. I don't see this as some kind of a SOP or a maneuver away from law. I see this as being grounded in the theoretical perspective that I will function in this world as if animals are valued. And the as-if principle is operating in this regard in the greater production of non-animal consumptive kinds of activities. Another aspect of all of this is my desire to stop talking about animals. I'm an animal-friendly person, an animal law person, but I resent very much when somebody is cruel to an animal, my having to say, this animal is worth better treatment. I want to say to that person, where do you get off acting out your violence against this animal? I didn't want to say, look how great women are. I want to say, where do you get off excluding people who have a lot to offer you are not even aware of? Right? I want to turn the spotlight away from animals, and I want to turn it directly on those people who would act in callous disregard of their interests. So how would one do that? You have to shift the presumption and the burden of justification of what is done. So I worked on some legislation in California, a little tiny municipality, West Hollywood, and I drafted this ban on declawing cats. You know, before this law, you could take your cat to the vet and say, cut off its toes, I don't like it, it claws the furniture, because that is what declawing is. It's not peeling off the nail, it's chopping off the first part of the digit. Veterinarians wouldn't explain to them, you know, I'm cutting off their toes. They'd say, okay, because the client here is the human, the owner of the cat. So what does this law does? It says if you want to take your cat to the vet and cut off its toes, you'd better have a really good medically necessary reason from the cat's perspective. So the law bans it except for those procedures on cats who need to have a toe or two cut off because they got an infected toe or a congenital defect, something like that. The presumption is you justify it. And when you justify it on the basis of the animal's needs, not on your convenience. And that is the effort then to switch the presumption. that law is under attack. I can't say that that is, you know, a done deal. The California Vet Medical Association sued the city of West Hollywood and won on the basis that the veterinary medical associations have the right to regulate vet medical practice, not city councils. And so that remains to be seen. It's on appeal as to what will happen in that particular case. I give that as an example. I would also give the example of, for example, Maine legislation that would provide for anyone being able to go to the AG or district attorney or anyone empowered to enforce an animal welfare law, and get injunctive relief to prevent an act that someone is about to engage in. So that in that process of legal inquiry, we get to hear the justifications of people who want to act out on the bodies of animals. It is those kinds of shifts. Number one, envisioning the world as an animal-friendly place. What would it look like? And without dealing with the animal issues specifically, try to create that world. And the second is turn the spotlight away from having to supplicate for animals. Please, I'm worth protection, and turn directly to those people who would exploit them. Those are the two avenues I hope that we can explore in addition to our continuing effort to validate the very real reasons that animals deserve protection. Thank you.
Good morning. It's lovely to be here, and I want to add also my thanks to our organizers and hosts for assembling this, and I'm pleased to be with such a group of wonderful folks working on behalf of animals and people who are interested in hearing what we have to say, so thank you all. I'm here to talk about the fact that we need to consider mediation for animals. Why? Why do I want to talk about that? Well, I want to talk about that because I think that our legal avenues that we currently have are defective in a couple of ways. Professors Reppy and Bryant also laid some of that foundation for me, but I want to talk a little bit more about that. Generally speaking, the law with regard to animal interests is not sufficiently developed to address the needs and interests of the parties. So that's number one. Number two, the law as a tool is too constrained. It is too constrained by concepts of precedent and stare decisis. That means reliance on what we've done in the past to tell us what we should do in the future. And it is not very good at dealing with things progressively because of that, or imaginatively. And it limits the remedies parties may think about. Okay, so that's why I think we need to address an alternative approach. And though that is my focus, I do want to say that it's really important to continue on all avenues. Okay, mediation is something of a critique to the adjudication model, but it is also a complement to it. So I just want to say that out front. Okay, so why is the law not working well? In addition to the context you already have before you, let me talk a little bit about the development of our relationship with animals. So culturally and socially, our relationships with animals have changed over time to one extent, and the recognition of our relationships, which haven't always changed. We've always had relationships with animals. So to a certain degree, we're beginning to recognize the relationships that we do have with animals. More than 2/3 of households in this country contain animals. It's a 360 billion plus industry a year. Okay, that's a reality about our relationship with animals, okay? We treat them more and more like family members in our day-to-day relationships with them when we're talking about companion animals, not when we're talking about the animals we eat or wear or other animals. But when we're talking specifically about companion animals, we treat them more and more like family members. And not just, oh, they're the pet part of the family, but we pay for radical medical treatments for them. We have vacation packages for them. We have insurance plans for them. There are spas. The list goes on and on, okay? We do not treat them like property, though they are legally property. Okay, so culturally, socially, we are not behaving like the law thinks we are behaving. Scientifically, we have major advances in our scientific understanding of animals. Animal behaviorists have helped us understand that the old 16th century Cartesian principles, the instrumentality, that mechanistic view of animals, does not hold up and should no longer serve as a basis for the distinctions in treatment between humans and animals. It may not be sufficient to get us to where we want to be, to say that they have rationality, they have cognitive capacities, they have linguistic ability, though we may not fully understand it. Comparing that to our own capacities, as Professor Bryant so eloquently stated, is not sufficient. But it surely should be sufficient to no longer allow the degradation of animals. Okay. So, what do we do about this? The difficulty is that the law has not kept pace with these evolving cultural, social, and scientific understandings. Okay? Me, as a mediator, as a lawyer, as an activist, I want to know what I can do about it now. I'm perfectly content to work for the future. I'm perfectly content to do law reform and think about long-term solutions. But I get impatient. Okay, lives are at stake right now. What do we do about it now? And so that's why I began to look at alternatives that we need to look at and can implement now while the rest of this evolves. All right, so let's look at how it works a little bit. What do we currently do? We currently do legislation and litigation, and people will talk enough about that I don't need to. But let me give you a concrete example of some of the difficulties of legal applications in an animal law setting. Okay, you have a dog, you take your dog to the vet for shots. The dog is there, the vet makes a mistake, operates on, and paralyzes your dog. What recourse do you have? Now, and again, there's lots of good vets out there. I'm using this as an example. You can go after the vet with the state or local licensing agency. You can try and have the vet sanction, the license removed, something like that. You can do a campaign, a publicity campaign against the vet, or you could sue. In some states, we don't even have veterinary malpractice claims. They don't exist yet. Though they're professionals, you can't sue them for malpractice. You can certainly sue them for negligence and breach of contract, but not for malpractice. Where you can, or where you bring the other suits, your recovery is going to be limited by the fact that the dog is seen as property. Again, some states allow for non-economic damage recovery, but most do not. So that means you'd be able to get the market value of the dog, maybe the replacement value of your dog. If you bought the dog at the pound 4 years ago for $20, the dog has no market value. There's no secondary market for used companion animals. There's no blue book, right, for these animals. There really is no market value. So what is your recovery? Okay, so difficulty. And obviously, if you have specialized training, there's other reasons that you can try to enhance your recovery. But what this demonstrates, I think, is a built-in legal and economic inequity. Veterinary practice is predicated on the idea that people treat their animals other than as property. Predicated on that, okay? That's an economic reality. If you have a television set and you paid $100 for it, it breaks, and to fix it is going to cost $400. What do you do? Typically, you throw out that television set and you purchase a new one for $100 because you're not going to pay $400 to fix something that's worth less than that has no market value equal to it. Okay? It's not a rational economic choice. Okay? Therefore, what can we deduce from that? People are making these kinds of decisions all the time. People are spending hundreds of thousands of dollars a year on veterinary services for their dogs who have, as we've just discovered, no market value. That means people are not acting rationally in the legal system. One of the difficulties we have is the legal system assumes rational actors. Now, I think people are acting rationally. So how do we bring these things together? Okay, it's not a legal or economic rational act under current concepts, so we need to change our concepts. So people are working on that, and that's very good, but the law is going to move very slowly here. Okay, so what can we do? Well, let me give you a couple other quick contexts, and then we'll talk about what can we do. In the divorce setting, if you're divorcing your partner, and you have a dog. Let's say the wife purchased the dog for the husband as a gift during the marriage. In some states, the dog is owned by the husband because it was a gift. In other states, if the dog was purchased with marital property, assets of marital property, then the dog is marital property. But let's also say further that the wife is the one who cares for the dog, walks the dog, feeds the dog. So basically, the wife is what we might call the beneficial owner. The husband is what we might call the title owner. What do the courts do? Okay, the dog is property. How do the courts decide what to do? Well, what do they do with other property? They find out who the owner is and they award ownership, right? They say if it's your property, you get to keep that property. Here, if the title is not clear or if the title is held jointly, what does the court do with that kind of property in a divorce setting? Well, if the parties can't agree to a distribution, then typically the court orders the asset sold and then the proceeds distributed. Okay, how does that work? We're going to sell the dog. You know, it's been in the family for 4 years. What are you going to get? What are you going to distribute? Doesn't work really well. Even if the parties can agree to the distribution, and they say to the court, we've decided the wife is going to get custody, but the husband's going to get visitation. Husband's also going to pay for some support because this is a part of the family. We've agreed to this. We just want you to add it to our court order, our judgment for divorce, our decree. And the court says, no, I can't do that. Can't do that. No authority to do that. No authority to award custody, visitation, or support for property, even when the parties so wish. Okay, problem. All right, one last setting, cruelty. In a cruelty case, there are 4 interests at stake, that of the defendant, the state, and we're talking about animals, so the owner in this setting of the animal and the animal. The court, however, can only address the first 2, that of the defendant and the state. The interest of the owner might be addressed in a civil setting. If someone harms my dog, I can sue them civilly. And again, we're going to have limitations on recovery that I already talked about. What about the interest of the animal? The court is not able to address the interest of the animal. And this is interesting because this is one setting in which the state has, as Professor Reppy already said, vested what should be rights in the animal. You ought to be able to say that animal cruelty is really just a way of saying animals should have the right to be free from being abused, right? From being treated cruelly unnecessarily. But there's no recourse for the animal, no way to measure the harm to the animal, and no way to compensate the animal. Okay, so taking these matters before the courts doesn't necessarily help the person caring for the animal, doesn't necessarily help the progression of animal law, may in fact sometimes be regressive to the extent that we're participating in a system that contributes to the ongoing justification, objectification of animals, and clearly doesn't necessarily help the animal. So, mediation as an alternative. What can we do? Well, first of all, for those who don't know what mediation is very simply a facilitated negotiation. If there are 2 students who come into my office and have a problem and they want me to help them out, I can act as the mediator. I'm a neutral. I don't have a stake in the outcome. I can promise them confidentiality. And basically, I'm trying to help them talk to one another and work out their own problem, solve their own problem, and come up with their own solution. That's basically what mediation is. Why is it useful? Well, sometimes it's free. Courts offer it free. Community services offer it for free. It's efficient. You can do it in 2 hours. You can come, I need a mediation, do it and be done, as opposed to the litigation process, which we understand is lengthy and costly. And most importantly, there's significant control over the process and outcome by the parties. So mediation is a very tempting opportunity for people. There are, however, of course, critiques of mediation as a process. One critique is that it offers us what's called private justice rather than public justice. And we live in a society where we think public justice is important, or at least we say that we do. And this is private results, and that bothers some people. Another critique is that in mediation, you do not have to follow precedent, and you do not develop precedent. And since our law is precedent-driven, that's a problem. So people could say, well, yes, the courts all say we should have this outcome, but in our mediation, we choose this outcome. And some people find that problematic. And the third critique is that it's not appropriate for rights-based interests determination. So in other words, if you have a dispute that's rights-based, constitutional, say, then this is not a setting that's going to help you very much. All right, responses to the critique. Mediation is no greater risk for private justice than any other. We know the statistics. Of the cases that are filed, and this is people who have already chosen not to solve their problems on their own, of the cases that are filed, we're at 90 8%, we think, of the criminal cases are being settled before they get to trial. And they're both above 97%, right? Criminal and civil cases are being settled. So that means we have private settlements already. And generally speaking, less so in the criminal context, but in the civil context, there are no constraints to what the parties can agree to. It's just what the parties agree to. Again, in class actions, there are some constraints, there are some other issues. So we don't really have a problem with saying mediation is private justice because we already have private justice. And in those settings, too, people can choose to follow or not precedent, and they do not develop precedent in a public way. What about the determination of rights-based disputes? Well, here I think this is a good critique of mediation and one that limits the appropriate use of mediation. I think if you have a constitutional standing issue that you want to bring, if you want to say animals have the right to come to court on their own, somehow, then mediating that issue is not going to be very useful because your premise is that they should have this right always for everywhere, whatever context. And saying that in this particular case we have standing doesn't necessarily help move that argument or dialogue forward. So you have those kinds of rights-based disputes, constitutional kinds of principles. I do think mediation is not necessarily the appropriate technique. However, it's certainly no worse a technique than what we have. It's one tool, and therefore we should consider its use. Okay. So mediation in the context of those three situations that I talked about, what would happen if we mediated them? So in the vet situation, well, the parties decide what's important to them. And this is what I think is wonderful about mediation. The parties have already chosen in their lives how to value things. They have chosen to value animals in a particular way. And the mediation outcome can continue to honor the choices that people have made. The vet can choose to pay more money than he or she might otherwise be required to pay at court. Why on earth would they do that? Well, they might want to avoid the reputational problem. They might want to avoid a malpractice claim. They might want to avoid insurance getting involved. They might want to save, actually, time. They might want to save a valued client. It might have been an honest mistake, and they want to note it and move on. The parties can choose other things that the courts cannot award. The party who feels harmed can maybe ask for an apology. I tell my students this when I teach mediation all the time, and they think I'm crazy until they start mediating. They think it's just one of those things. People want apologies. They want to be heard. We say that about mediation a lot, and that the process can offer this. Until they start mediating, they're like, wow, they just really want an apology. That's wild. Sometimes people want to be acknowledged. They want the harm to be acknowledged, and this is actually something the courts can't do. The harm that people are upset about when their animals or the animals that they live with or care for are harmed cannot typically be acknowledged in court. Our laws have not evolved that far. Vets can offer free services. They can agree to do additional continuing education. They can, the party harmed can choose not to report to the licensing. So we have a variety of options, and they're limited only by the creativity of the parties. In a divorce, what can we do in the divorce? Well, the mediator, despite the fact that the law does not authorize it, the mediator can help the parties craft a binding contract. You have to be careful, because if there's a dispute as to the contract, you want it to be enforceable at law if the parties need to come to court later on, but you can do that. You can build in some economic penalties. If there's visitation, you can say, well, if you violate this contract, though the contract itself wouldn't be enforceable, the court couldn't order somebody to pay visitation, to pay support, or to do visitation for an animal. But you can build into the contract that if you violate this contract, you have liquidated damages. That a court can deal with. And they can say, here's the contract, here's the breach, all right, here's the damages. You win. So the mediator can go much further than the court in that situation. And in cruelty, what can the mediator do in the cruelty cases? Well, the mediator can actually address the harm, right? The real harm, the harm and suffering to the owners, could perhaps address the counseling need for the person who abused the animal, can also create special remedies for the animals that are not available at law, providing for the care for the animal. See, the animal, if the animal is paralyzed, some kind of assistive technology, right? So the animal can still be ambulatory. So that's a wonderful thing that they can do in the cruelty case. So how far should we go with mediation? I've said lovely things about it, but how far should we go? Should we, like the labor law area, should we say that arbitration in the labor law area is sort of the way to handle those cases? Should mediation be the way to handle animal law cases? I don't actually think so. I think mediation serves as a wonderful complement to and critique of the adjudication process and should be seen as one of those tools that we have in our toolkit to help animals. So, in conclusion, why should mediation be appropriate for animal law disputes? Because mediation is an option for all areas of other legal disputes, and if there's no limitation for other areas of law, there should be no limitation here. Because mediation can successfully address the parties' real concerns. Because mediation is not as limited as the law because it doesn't have to rely on past decisions. Because mediation can address some questions now while the law still evolves. Mediation can also be a testing ground for what seems just and equitable to the parties, and that can actually inform the development of law. The law is currently not working optimally, I think we can agree on that, for the benefit of animals or those who care for them. And until change occurs so that it does, mediation presents the opportunity for real solutions to real problems now. Thank you.
So we're fortunate today to have a number of different groups represented in the audience, including some folks from the vet school at NC State who I think might have some thoughts on the exemptions that Bill Reppy discussed. We've got some activists here, I'm quite sure, who are veterans of the women's movement and may have some thoughts about Professor Bryant's remarks. And we've got attorneys here who've got experience in both litigation and alternative dispute resolution. So I think we've probably got a lot of comments and questions in the audience, and we've got 5 or 10 minutes to go through some of those. So sort of throw your hands up and let's get started. All right, with the red shirt.
Professor Reppy, you see one of the remedies as being going into the courts and arguing the unconstitutionality of the exemptions. Why wouldn't they just, instead of saying, okay, all these exemptions are unconstitutional, just broaden the spectrum and make them apply to all people who interact with animals?
Because it's really impossible to describe the class in such a way that there's a fine line drawn. So, and criminal statutes have to give notice. You interact frequently with animals is much too vague, I believe, to be a valid criminal law. Moreover, this very issue, can we add words to a statute to cure it, was recently before the United States Supreme Court in a New Hampshire abortion case. And the answer was the legislature should be the particular party to fix it up. It's not up for the courts to actually add language. You can strike it, but you don't normally add. And it's so hard to know what to add here to make everybody treated equally. I don't think it can be done, but it's a good question. I explore that in the article. Didn't have time in my oral presentation.
Kelly.
This is a veterinary-related question for Professor Hessler. One of the things that we as veterinarians deal with all the time is the economic decisions that people make, and even the same individual who may choose to spend $20,000 rehabilitating a dressage horse is reluctant to even spend $50 or $60 spaying the barn cat that lives in the same area as the horse. And so it's not even just an individual perspective as far as how they view animals, but even within individuals, they have a hierarchy of the value of certain animals, and we know that people are more willing to spend large amounts of money on a dog than they are a cat or a guinea pig, and it is perceived as the purchase value of that animal and the replacement value of that animal. Could you address that?
Well, I think that you're right, and I think it depends on how humans interact with animals, and to the degree that someone has a dressage horse or hunting dogs, they have a different relationship with those animals than they do with purely companion animals. For the people that I've seen who have purely companion animals, I've seen people spend thousands and thousands of dollars on chemotherapy, for instance, for a dog or a cat. So I've seen them make those kinds of choices. I think to some degree it's an individual choice and there is some consistency within those individuals. But when people have different relationships, or to the degree they recognize different relationships with the animals in their lives, then you're going to have different outcomes. And I do think that I'm not saying that economic choice you know, the economics shouldn't come into play. It comes into play even with humans. You know, how long are you going to keep somebody in hospice or whatever? You know, it's unfortunate, and I don't think it should necessarily, but it's a reality. But I do think that there are people who are making the choice to care for to the degree that people treat their animals more as family members, and to the degree that they choose to value them as other than economic entities, then they make choices that are consistent with those decisions. So the dressage horse, there's also an economic interest in that relationship. But to the degree there really is not an economic interest in the relationship of a purely companion relationship, then they're going to make different choices. And so the outcome should be consistent with those choices that people have made. That's all I'm saying.
Taimie's got a question.
Could I just follow up with you, since you had raised the question? I wonder how you deal with that problem. You're perceiving it as a problem or an issue that you come across, and I wonder how you deal with it, because I can imagine some different scenarios, like explaining why it's in the best interest of the horse that the barn cat be spayed without, you know, having all these kittens running around, or trying to educate them about the value of the cat being equal to the value of the horse. I'm just curious as to how you navigate your way in those settings.
Not just speaking from my perspective, but just as the veterinary's perspective, I don't think that as veterinarians we feel comfortable putting pressure on people to say, well, your cat's been hit by a car and we know you don't have any money, but if you were a good person, you would spend the $10,000 it's going to take to put this cat back together.
Isn't that kind of a different situation?
Well, but
than the paying $50 to spay neuter the barn cat and $10,000 on the horse?
Except that you're looking at an elective procedure for the cat. Spaying it will not necessarily save its life versus the cat that's been, if that same cat goes out and gets hit on the road in front of the barn. The other thing that we deal with is not just people not being willing to spend money, but something that you all may not have thought about is we're getting into the realm with some animals where people have enormous amounts of money and they're willing to go to great lengths to try to keep these animals alive, maybe in situations where it's not a kindness for the animal's life to be extended, and that's getting to be as an uncomfortable a situation for us in the veterinary community as when is enough enough, and how do we present euthanasia as an option to the clients, and should euthanasia ever be offered as an option? Those are all different arguments that, again, some of them are economic driven and some are ethically driven. So there are a lot of very difficult questions that we face every day.
I think you raised them very well, and to me they're all medical ethical questions, right? I mean, the economics comes in. We have the same thing sort of on the human side, whether the economics should come in, right? But really it's your professional medical judgment which gets into values, right? How people, and we have the same thing with human-human interaction. So I think you raise a wonderful sort of question that needs more exploration.
Thank you. Yes, it did.
I think we've got a hand up in the back.
I just wanted to follow up on that same thing. I do a lot of the same type of work as Dr. Ferris with the low-cost spay-neuter. And I think the bigger problem is not so much, you can tell the dressage horse owner, you can educate them briefly about how it's great to spay-neuter this cat. And they have the money, and they follow up, and they do it. And the low-income owners that care about their animals, they find a way to get it done. It's more the people that just plain don't care. They grew up in generations of, dogs reproduce in their backyard, and their population control is they get hit on the road, and they never even get so much as a rabies vaccine. And and occasionally there's one that they really do care about that they bring to the vet, and their concern is, well, why can't you put me on a payment plan or do it for free, or and they don't understand that you just can't do that all the time, and that's really a big problem. Is the people that don't care is where we as veterinarians run up against a wall. They won't even let you euthanize it. They want to take it home and shoot it, or just take it home and see if they'll get better on its own. And it's suffering. It's suffering. What do we do then when they won't even let us they won't even sign it over to us? That's where we run into trouble.
I'm not sure that there's an answer for that, but again, I think it's like a medical ethical concern, right? I mean, there are doctors who see parents bring children in and make choices for their children that the doctors don't approve of, or people who are caring for elderly people who can't care for themselves and make choices that the doctors don't approve of. And I do think it's a huge educational issue on both sides, right? What does it mean to be a parent? What does it mean to be someone who's responsible for the care of an animal, right? I think there's an education on that side. And then the doctors, you all are in a wonderful position to help with that kind of education and help with the evolution of that dialogue.
Just as a follow-up response as well, when I look at the situation in Los Angeles, for example, I think that too much of the burden is placed on lawyers or school teachers to educate the kids that come into their classes, or veterinarians and educating them. And I look around and I think, why don't we have the Los Angeles Free Clinic for pets? We have the Los Angeles Free Clinic for indigent families. And if you have these institutions in the society that provide services for animals, people begin to hear, wow, vet services are available and vet services are important, and there's kind of an institutional educational impact that occurs through that process. And that's one of the areas I'd like to explore, because I think the society educates by the institutions that it has available in its midst.
And again, you know, that's what I do. Is we have a low-cost spay-neuter group, and we're mobile, and we go into the lower income areas, which is where the bigger part of the problem is from an overpopulation standpoint. Yeah. And you know, but a lot of it, there's not enough of us, and it has to just start even deeper. You know, I think
and it shouldn't come all from your pockets. It's the free. It should come from a donor base, and it should be full-service vet clinic. You can see, I think, really big here, and I'm not having any expertise in the field.
And it has to also come more from just, you know, PetSmart charities, or you know, the few big donors that are out there. You know, the federal and state governments really need to start getting involved. This is just a tremendous problem, from, you know, an abuse situation to, you know, animals won't be abused when there's a short supply and you can't find one in a ditch. They're not going to abuse them anymore. You know, when it becomes a valued commodity, even if you're still going to call it, you know, label it like a knapsack or a chair, it's still valued. And when it has some value, it won't be abused and neglected anymore.
We've got even further in the back, I think, a comment or question.
I really appreciated the comments by all of you, but I particularly related to what you said, Professor Bryant, about changing our paradigm. I think that is what we're going to have to do before any of the legislative work that we all do works, is to change our paradigm. What would you suggest would be the most effective way? I mean, you talk about changing the institutional options that are out there, free animal services, vegan restaurants, and my husband keeps trying to get us to open one, and that scares me to death. So please give me another option of what we can do.
I'll come peel the potatoes.
Well, we may still do that anyhow, but what about teaching kids in school? What can we do what would your thought be about the most effective way to change our society's paradigm about animals?
First, perhaps it was muted in my conclusion, but I came full circle to actually saying that I thought good work was being done by way of the similarity argument, and this is why. The similarity argument makes sense on a kind of sociocultural level. Where the similarity argument begins to break down under tremendous pressure is when there are legal entitlements at stake. And so the stakeholders in chimpanzees as their property are going to push harder on the similarity argument than would somebody who is presented with the argument in a broader social context. So I present the turn the spotlight and the live in the world as if it is animal friendly as another tool in the toolkit, which has been sort of the theme of this panel. So the first thing I want to say is not that I think that the previous paradigm is not effective in some contexts. It's not a paradigm I'm comfortable with because of my history. Now, having said that, then what do? I think you have to, one, look for the spaces inside the laws that already exist so that your primary focus is on getting people who use animals to justify what they do. So that little cat declaw effort, even if it turns into signage in the vet clinic, this is what it means when you declaw a cat, so that the veterinarian isn't placed in the position of saying, you really want this to happen, but look what the consequence would be for the cat. There's an inherent conflict of interest there between caring for the cat and responding to the client. So signage takes it outside of what the veterinarian is responsible for doing. And so you look for the spaces that then require the person to think, why do I really want to do this, and would I do this if pushed to explain my motives in public? And so I don't think, since this is a relatively new kind of theoretical framework, I can't give you a checklist of this is what you do first and this is what you do next. I just know that when I'm looking at legislative projects, I ground myself, I anchor myself in what I'm comfortable doing, which is not talking about the animals, but forcing a justification on the users, and living in the world as though it is the world that I want it to be. And when I do that, I'm anchored, and I choose certain projects that other people wouldn't choose. I reject some projects that other people may very successfully go forward with.
Me to South Carolina and talk to cockfighters about why they,
Everybody here has got a really tough job.
I know. Thank you.
We've got a couple more, Pat.
This is to Professor Reppy. I really believe that the issue of exemption is one of the most important things in North Carolina and other states, and I really applaud you for pursuing this. My question is, after you settle this and get it out of the way, can we take the law back to where it used to be in animal cruelty of every living creature?
The North Carolina law exempts fish right now for any cruelty, and that happened when a trial court judge thought that the law was so stupid he held it unconstitutional because it included running over an insect in your driveway. And so the legislature responded to that trial court decision by eliminating insects, and for who knows why included fish, which we know feel pain. That's on the agenda, Pat, but I think it's pretty low down. I mean, it's insects and fish that are being excluded right now.
Well, I know that when the misdemeanor added the felony to it is when the big change was, and it was every living creature before that, that one of the legislators said, if there's a possum on my back porch and I hit it in the head, I don't want to be charged for cruelty. Well, he should be.
Well, possums are definitely covered. The one change that I think needs to be made is fish, but I must tell you, I'm going to go after those exemptions and not care about the fish until I get rid of the exemptions.
Gary.
Bill, I have a question on your strategy. I did want to say, though, Taimie, you mentioned about the idea of low-cost services. In Britain, they have something called the PDSA, which I think stands for People's Dispensary for Sick Animals, which does exactly what you're talking about. The problem has been efforts in this country to do that sort of thing have been met with a lot of opposition, primarily from the veterinary establishment. So it is my hope that the veterinary establishment will move in certain directions. I mean, the problem is people have wanted to do that, but they run into problems with the veterinarians. Bill, as I understand your equal protection argument, I mean, first of all, one might argue that you need the exemptions there because the statutes prohibit unnecessary suffering and unjustified suffering, and those are normative, not descriptive terms. And these are criminal statutes, and you got to have notice, which is why I suspect almost everybody has exemptions, and even states that don't have exemptions read those exemptions in. But if you make an equal protection argument, are you going to get anything more than the North Carolina court saying, okay, you can't inflict any pain and suffering that isn't part of the institutional customs, you know, because that's consistent with a huge amount of pain and suffering. I mean, really, what your argument says is basically that if you can't economically justify the imposition of pain and suffering, then it shouldn't be excluded from the anti-cruelty law. And indeed, my sense is, I haven't done an empirical survey of this, but my sense is that's the way most states interpret the exemptions, whether they're explicit or implicit in their anti-cruelty laws, is they say that you can't inflict pain and suffering that goes outside of what is customary in that particular. But I mean, you know, look, if you're a cow, I mean, what the hell? I mean, you know, I mean, if you, You're still going to be able to castrate animals without anesthesia, dehorn them, brand them, do all sorts of things. And to the extent you say, well, you can't brand your dog, the answer is the rational basis is it identifies property. There's a rational, there's, you know, I mean, what are you getting from this? What I'm curious about is what are you going to get? If you win, what do you get?
All the exemptions fall out, and the legislature is going to probably do something really quickly. And they'll probably join up with the more common exemptions in other states that restrict it to commonly accepted practices. Branding is a commonly accepted practice. I probably couldn't hope in this particular state for a better outcome than that. But it is very clear that the exemption, it was intended to extend to felonious cruelty. That was the original occasion for creating the exemption. So malice malicious conduct is exempt.
I mean, that is, I agree, that is a strange, that's somewhat unique in my experience in terms of my understanding of anti-cruelty laws. But I also think sadistic infliction of pain and suffering, felonious infliction of pain and suffering, what you're talking about, represents such a small fraction of the pain and suffering that is imposed. Most 99.999% of the pain and suffering imposed, particularly on animals that we eat, is part of custom, it's part of the institutionalized exploitation. And so it's not clear to me, you know, it's not clear to me at the end what we're really getting from this approach. But it's interesting.
And Gary, that's actually a perfect lead into our second panel, but we need to take a break before we do that. I think we're probably a little bit behind schedule, so maybe be back.
1 minute. We're 1 minute behind.
Oh, I don't know. But in any event, be back here in about 10 minutes, and our next panel is going to be about animal agriculture and factory farming. Is that right? I think we're supposed to be done with at 11:15.
I know. Oh, I always do.